All right, so we're going to start a new unit today. We're going to start in the Civil Liberties and Civil Rights unit. And for KVA students, this is what you'll be working off of. For face-to-face students, we have the packet, which you should have received today. And I'm probably just going to stick to this because it is essentially the same question set, just in a different format. So you can see right there when we go to the questions for today, it's the same thing. Okay, but just for simplicity's sake, I'm going to work off of the print materials, and I just have this in a PDF file, which again, it's the same thing that's on Canvas. And if you're in person today, you should receive this packet. It's kind of a light brownish color with this cover here. Okay, so civil liberties and civil rights. First thing we're going to do is go through the essential questions and enduring understanding and all that stuff like we normally do. So here we go. So what extent does the U.S. Constitution and its amendments protect against undue government infringement on essential liberties from individual discrimination? It should say how the Supreme Court rulings define civil liberties and civil rights. The enduring understanding is provisions of the U.S. Constitution's Bill of Rights are continually being interpreted to balance the power of government and the civil liberties of individuals. So that's a really important deal. Now, think all through the past year with the mask mandates and the lockdowns a year ago and all that, we really see that, don't we? We see the balance against an individual desire maybe to go out and not have to quarantine versus the government's power to say, no, you're going to quarantine. A little close to home right now at the moment. Anyway, the learning objectives explain how the U.S. Constitution protects individual liberties and rights, and then describe the rights protected in the Bill of Rights. So that's mostly what we're going to do today. And then the outline, Bill of Rights is specifically designed to protect individual liberties and rights. We have a definition of civil liberties, which we're going to talk about in a minute. Civil liberties are constitutionally established guarantees and freedoms that protect citizens' opinions and property against arbitrary government interference. The application of the Bill of Rights is continuously interpreted by the courts. The Bill of Rights consists of the first 10 amendments to the Constitution, which enumerate the liberties and rights of individuals. So first thing we're going to do is compare. What do we mean by civil rights and civil liberties? A lot of people erroneously use these terms interchangeably, and we're going to kind of dispel that. So civil liberties, and you might want to write this down. In fact, maybe, hold on one second. Okay, so civil liberties are individual rights guaranteed by placing limits on government power. So, for example, the First Amendment to the Constitution says Congress shall make no law respecting an establishment of religion. So you can see that Congress is limited to protect individual rights. So the same is true for freedom of speech and all the other protections in the Bill of Rights. They're protected by placing limits on government. Civil rights are different. Civil rights are created by government by establishing laws that protect groups of people. So, for example, prior to the civil rights era, there was widespread racial discrimination sanctioned by law because of the after effects of Plessy versus Ferguson. And even though we had the Supreme Court weigh in, it really took Congress to pass a law that made it illegal to discriminate against people on the basis of race. So they established a category and offer protection. So rights are created by government. The same with the Americans with Disabilities Act. No one chooses to be disabled, and I don't think people intentionally seek to discriminate. But when there are no laws requiring equal access, that has a discriminatory effect. So rights of access to buildings were created by Congress. So once again, to sum up, civil liberties are protected by limiting government power. Civil rights are created by exercising government power, when government takes action to protect groups of people. Okay, let's slow down. I'm not going to. First words of the First Amendment are once again, Congress shall make no law, and again, emphasis on the idea that Congress is limited. Okay, what do these words indicate regarding how the Constitution protects the rights of the people? Again, these are civil liberties we're talking about in the Bill of Rights. Okay, once again, Bill of Rights, civil liberties, and again, how are they protected? By limiting government action, limiting government power, I should say. Okay, what we're going to do now is just real quickly go through the amendments. I'm not going to write these down, so you can just fill them in on your own. But First Amendment has all the big ones. And by the way, there's something called the preferred position doctrine, which we should probably talk about at some point. But indicating that the ordering of the amendments have some meaning. So the First Amendment, obviously, religion, freedom of speech, freedom of the press, right to peaceably assemble, right to petition government for redress of grievances. Second Amendment is the right to bear arms, which, by the way, you might want to put a little asterisk by that one. That was recently, as early as 2010, determined to be a fundamental right. So states cannot infringe upon your right to keep and bear arms. Third Amendment's the ban on quartering of soldiers. We don't talk about that too much because it's kind of moot. Don't have that situation arise anymore. But at the time, it was a really big deal. Fourth Amendment has a bunch of stuff. Let's go ahead and take a look at the Fourth Amendment. Fourth Amendment, right of the people to be secure in their persons, houses, papers in effect against unreasonable search and seizure shall not be violated. No warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So this is a privacy-related protection in the Fourth Amendment. Let's go ahead and stay on this. Fifth Amendment has a bunch of stuff. Right against self-incrimination. Don't need to go through every single one of them, but ban on double jeopardy. You can't be tried twice for the same offense. Government can't just keep plugging away until they get a conviction. They have one chance at a criminal trial for a given crime. And very importantly, we have our first due process clause. You cannot be deprived of your life, liberty, or property without due process of law. And then finally, we have the takings clause in the Fifth Amendment. Sixth Amendment is the basic due process with regard to criminal procedure. Have a right to a speedy public trial, and speedy in our system of justice can be years, but it's relative, I guess. An impartial jury in the state and district where the crime shall have been committed. They can't ship you off to Maine if you commit a crime in Texas to stand trial. You got to be tried by fellow Texans if you commit a crime here. And then right to confront witnesses. So this is a basic due process right. You have a right to defend yourself, and have a compulsory process for obtaining witnesses. So you can you can subpoena witnesses. And then, of course, this one was not incorporated until the Gideon case. We'll talk more about that. But the assistance of counsel. Don't forget, the entire Bill of Rights for many, many years was seen as limitations only on federal power. It wasn't until the 14th Amendment that started to apply to the states. Seventh Amendment, in suits in common law, so in civil matters, you can have a jury trial. You have a right to a jury trial. Eighth Amendment is the ban on cruel and unusual punishment and excessive bail. And if you don't know what bail is, usually when you commit a crime, they set a dollar amount that'll get you out of jail pending trial if it's a relatively moderate crime. Capital murder, probably held without bail, but again, it has to be reasonable. Ninth Amendment is the catch-all. The enumeration of certain rights shall not be construed to deny or disparage others retained by the people. So they're not claiming that these are the only rights that are out there. And then the 10th Amendment, you have reserved powers. Okay, going back to the packet or the question set, if you're on KVA, we have this topic. Federalists and anti-federalists disagreed about whether to include a Bill of Rights in the Constitution. Federalists felt it wasn't needed, yet Anti-Federalists insisted on it as a prerequisite to the ratification of the Constitution. What evidence supports the Federalist view that listing certain rights might actually result in the limitation of rights? And I say to discuss the Schenck case, which we have not yet assigned, so I'll quickly hop over to that. So here's the Schenck versus United States case. This is a freedom of speech case that involved someone who violated the Espionage Act by mailing out flyers. And the famous takeaway from the Schenck case is that the Supreme Court looked at the First Amendment, which says Congress shall make no law abridging the freedom of speech. And they said, well, the Espionage Act is kind of important. We don't want people interfering with the military. So the famous line, fire in a crowded theater, which is in the opinion down here. Some speech does not merit constitutional protection. There's a clear and present danger, and basically carved out the idea of unprotected speech. So if we go back to the question set, what I'm getting at here is that, you have to ask the question, okay, when the Supreme Court started interpreting the First Amendment, they have something to interpret. The First Amendment is written down. Congress shall make no law abridging the freedom of speech. The Federalists believed if you start listing those laws instead of just assuming that they're fundamental rights, natural rights, you're going to open the door to government restrictions on speech. And that's exactly what happened in the Schenck case. The Supreme Court laid down a standard that there were categories of unprotected speech, and that as such, the amount of speech that you had after the Schenck case is diminished. And the Federalist viewpoint would be, well, if you hadn't listed it, you wouldn't have opened it up to that interpretation, and we would have just assumed that free speech is a fundamental right. So it gets a little bit confusing at times, but the main takeaway is, there is some disagreement about whether or not the Bill of Rights was needed. And, because the founders did believe in natural rights. And plus, the existence of the Ninth Amendment and things like privacy rights, which are not in the Constitution, and marital rights, which are not in the Constitution, prove that there are fundamental rights that are unstated. So just something to think about. Okay. In the interest of simplicity for my part, I'm going to keep going here, but that concludes the lesson for Tuesday. And I apologize if you're viewing this after you've already had class, but better than nothing, I guess. Obviously, I can't be there because of quarantine. Anyway, by the way, I feel fine. I'm completely, I don't want to get into it. Anyway, all right. So keep on plugging away. Topic 3.2, freedom of religion. All right. The enduring understanding and provisions of the Constitution, it's the same one as before. Learning objective, explain the extent to which the Supreme Court's interpretation of the First and Second Amendment reflects a commitment to individual liberty. And so we have two very important Supreme Court cases that root out the court's interpretation of the Establishment Clause and the Free Exercise Clause. And again, looking at the Constitution, that's here we have the Establishment Clause, here we have the Free Exercise Clause, both of which pertain to religion. Okay. So the preferred position doctrine, now I'll go over this when I get back, but once again, it's the prominence of the First Amendment, and basically there's a reason it was first, there's a reason religion is first, there's a reason speech is second, and it speaks to the fact that the founders were very cognizant of those First Amendment freedoms being the utmost importance in a free society. And so I think we're going to have a national discussion about free speech here, before too long, given what's happening in the world of social media. But anyway, okay, so let's jump into these cases. We have Engel versus Vitale and Wisconsin versus Yoder. And let's go ahead and take a look at these cases. All right, so let's take a look at Engel. So the background talks about the First Amendment and history of religion, and and yet we have elements of godliness in our currency, in God we trust, and and, God save the United States in this honorable court. There's a chaplain. I mean, there's all kinds of evidence that the founders were not completely godless. And yet we have this, provision in the First Amendment: Congress shall make no law respecting an establishment of religion. So they wanted to make it clear that government was not in the business of harboring religion. Okay, so here's the facts of Engel. Every day after the bell, kids in New York had to salute the flag. They had to stand up. They had to, say the pledge. And students and teachers voluntarily recited this school-provided prayer, which had been drafted by the state education agency. And you can read it right there for yourself. It is a non-denominational prayer. It doesn't make reference to any, type of religion. It just has a generic God. And it was said aloud in the presence of the teacher. And you can see students were not required to say this, but some of the kids were uncomfortable, and the parents made a fuss about it and sued. And they basically were trying to make, this something that the courts would look at. So what's the issue? Does the recitation of a prayer in public schools violate the Establishment Clause of the First Amendment? Well, I have some case law here you can look at. And there's a couple of flag salute cases. This one, in this flag salute case, if they didn't, they could be charged with insubordination. So, some of these ordinances in certain states about saluting the flag were a big deal. And they sued, and I believe in this case, there it is, mandatory flag salutes are unconstitutional. So, the next time you're walking down the hall and somebody, throws a fit about you, not, I mean, you should be respectful, but as a matter of constitutional law, you are under no obligation to salute the flag. It's kind of un-American not to do that, but, But as far as constitutional, you absolutely have a right to not salute the flag. You don't have to stand or anything like that. It's a free country, at least for now. Okay. Okay, and then we have some other one. We need to go through all these, but let's go through the basic argument. School sponsored prayer violated the Establishment Clause because it included the word Almighty God. It also violates the Free Exercise Clause because it has the effect of coercing children to participate, even though they're not required to, some peer pressure and all that. The teacher leads the students in prayer. That's a problem in a public school. Okay, the public school is an extension of the state government. Okay. And even though it's voluntary, again, peer pressure and so forth. Now, the other side is an argument that has been used successfully in the past. Religious heritage of the nation. Acknowledging that our country was not entirely godless when it was created. We have references to God and things like that. And again, New York's point of view, it's a declaration of faith. It's non-denominational. It's not deny any preference. And there goes my dog. Character building, citizenship education is important, and on and on and on. Okay, so this is a 6-1 ruling. Notice at the time the court was only 7 members. And here we have Justice Black writing the majority opinion. And majority is a school-sponsored prayer was unconstitutional because it violated the Establishment Clause. Okay, so going back to our question set. What are the facts of the case? Again, state of New York required students to recite, required students to have, as a part of the day, a voluntary prayer portion that included a generic reference to God. The issue is, does this violate the Establishment Clause? And really, more importantly, does this apply to the states? This is what we call an incorporation case, by the way. We'll talk more about that later. But the decision was yes. The Bill of Rights does apply to the states, and the state of New York could not require the recitation of the prayer, even if it's voluntary. Okay, so anytime you have an Establishment Clause issue, I like to talk about things like, Christmas trees and religious activities on school premises. Anytime you have an appearance of endorsement of religion, and a lot of times they pop up in schools, you have an Establishment Clause issue. One issue that came up here in the state of Texas, actually, there's I think it's the 10 Commandments posted outside of the courthouse, I believe. Not the courthouse, the State House. And that was one that the Supreme Court allowed because of the heritage and tradition argument. So anytime you have the appearance of an endorsement of any kind of religious content by government and its agents, so that could be a school, it could be a courthouse, the State House, anything like that, you have an Establishment Clause issue. Okay, Wisconsin versus Yoda. Yoder. I always I see YOD. I think Yoda. Let's take a look at that case, shall we? Here we go. Wisconsin versus Yoder. We have Amish people. Let's take a look at some Amish people. Okay, there they are. They have a very plain and simple lifestyle, we'll put it that way. They still travel by horse and buggy, don't believe in automation, things like that, certainly not iPhones or things that you'd find in a public school. So Wisconsin had a compulsory attendance law, and the Amish were afraid that if their kids were forced to go to public schools, they would learn values that are different from Amish values, particularly after they get through elementary school. And so they filed suit based on religious freedom, based on the free exercise clause, that they should be able to pull their kids out of school. Okay, so under what conditions does the state's interest in promoting compulsory education override the parents' First Amendment rights to freedom of religion? That is the issue. Okay, and again, you can read the case on your own for details. This is just a brief overview, but the arguments for Yoder won the day. The Amish and Mennonite communities' beliefs about the danger of formal education are sincere. Should not be forced to violate their own religious beliefs. The Amish community provides an alternative vocational education that prepares children for adult roles in the Amish community. So it's not like they're just, goofing off after they leave the 8th grade. They're doing on-the-job training, so to speak. They're law-abiding. These are not bad people, basically, and this is not physically or mentally harming the kids and doesn't disrupt the community. And this is important because this is a unanimous decision in favor of the Amish. Okay, so basically the court ruled that the family's religious beliefs and practices outweighed the state's interest in making the children attend school beyond the 8th grade. So basically, a victory for the Amish. All right, so what are some other common free exercise issues? Well, anytime a person's religion contradicts something the state would like to do, the common example that's easy to understand is mandatory vaccinations. If you have a religious belief that you don't trust vaccine, or you think it's violation of your religious rights to be vaccinated or something like that, can you keep your kids out of, or can you send your kids to public school even if they're not vaccinated? Well, there you have a state interest in healthy students that outweighs the individual interest, and so that's a free exercise clause where the state's going to win. So there's all kinds of weird cases with free exercise clause involving the drug use and stuff like that. There was a particular case where a person was smoking peyote, got denied unemployment benefits because he tested positive on a drug test, and the state interest in not having a bunch of drugged up employees outweighed the individual interest in using a ceremonial religious substance, smoking peyote as a part of a religious ceremony. In other words, state interest wins in that case as well. All right, topic 3.3, freedom of speech. This is a really, really important topic, and I'm almost tempted to just not go through this through this video, but I'll give you a short version because we are going to revisit all this stuff in class. But we'll just give you the basic introduction here, and then call it even on the notes and stuff. All right, here we go. We have a couple of important cases, Tinker versus Des Moines. There's a bunch of stuff related to free speech that, again, it's going to take some time to process, but we'll start with some basic things. Okay. This past summer, we saw some just terrible rioting and stuff like that, and just all kinds of violations of what the commonly accepted rules are with regard to that. But if the states had wanted to, they could have certainly reined that in with police power. But and the reason is because the court has ruled that state and local governments may impose reasonable time, place, and manner restrictions. Here they go, time, place, and manner restrictions. But here's the catch: they have to be content neutral. Content neutral. Okay. So an example that I talk about in class, and I'll just give you the short version of it. Skokie, Illinois is a Jewish community. There was an incident in the late 1970s where a group of Nazis, okay, like we're talking actual Nazis, not these, like legitimate uniform wearing skinhead Nazis. Okay, they wanted to march in Skokie, Illinois in some kind of community event or something like that, and they were denied a parade permit. Well, the reason they were denied is because it's, Nazis marching in a Jewish community. Hello. And by the way, this is only, one generation removed from the Holocaust. So, it just doesn't look good to have Nazis march. And of course, the town was like, no Nazis. And the Supreme Court says, well, First Amendment, right of assembly. And so they lost. The town actually had to allow these Nazis to march, and of course that seems absurd, but that's what content neutrality is. You can't let the Girl Scouts have their little parade or whatever and deny the Nazis just because you don't like them. Okay. Now this stuff is not officially, this falls in the category of unprotected speech. So right here we get into this stuff. It's unprotected speech, and what we're going to talk about is defamation. And I'm going to mostly defer to when I return to go over this stuff. So I don't know if I want to get into it because this is not a required case. So why don't we do this? Let's jump ahead to the. I guess we can do this one right here. I'll real quickly do the fill in the blanks. All right. Defamation occurs. That's when you say something negative about someone that's false. Okay. When the material is published, false, and damages someone's reputation. Written defamation is called libel. Verbal defamation is called slander. The New York Times versus Sullivan case is too complicated to go through in this video, so we'll defer to that until I get back. Okay. Speech that creates a clear and present danger. That is a category of unprotected speech. I guess I should have a big label. Unprotected speech. Okay. Defamatory and obscene statements are unprotected. Clear and present danger speech is unprotected. So the Supreme Court has ruled that there are limits to speech when it creates an imminent danger to public harm or national security. Okay. And that's a pretty broad, standard. That's it's pretty, I know that we just had the impeachment over, Trump and, calling on people to fight like hell. And, does that create an imminent danger? Any reasonable constitutional scholar would be like, now that's protected speech. And of course, some people choosing to take that literally, if it was Trump inciting them or someone else, that's another matter. But the speaker who is saying something that is protected speech, you can advocate violent overthrow of the government. You can't just do it where there's a sense of immediacy. And, that's where the gray area is with all that. But that's a whole other thing I don't want to get into right now. But anyway, we have the Tinker case, which is always fun to talk about. So let's look quickly. Here's Tinker versus Des Moines. There they are. These are the armbands that the kids were wearing. So let's get into that case real quick and talk through that. Okay, Tinker versus Des Moines is typically referred to as a symbolic speech case. And basically you have these 8th graders who are protesting the Vietnam War. And, you may think, what's the big deal? Well, people were getting killed. I mean, my dad's a Vietnam vet, and, not everybody was against the war. There are some people that thought they were trying to do something at least. Anyway, so they wore the armbands. They got suspended. And the issue is, does wearing an armband constitute protected speech? And again, you guys are going to have to read these cases on your own. I'm just kind of talking through them real briefly here. But the arguments that won, students, whether in school or out of school, are persons under the Constitution that possess fundamental rights. Public schools are part of state government. The 14th Amendment protects people from infringement of First Amendment rights to free speech. Wearing the armbands was a form of speech. Wasn't disruptive, didn't infringe on any other students' rights. And schools should be a place to engage in some sort of discourse for different ideas, allowing students to express, them as part of the deal. Says, and 7-2 decision, wearing the armbands is a form of speech. And students do not lose their rights to free speech the moment they enter the school, doorway. And that's kind of the gist of that case. So again, facts: kids wearing armbands got suspended. The issue: do students have a right to free speech? And if so, is there such a thing as symbolic speech? Answer: yes. The decision: the kids were allowed to wear the armbands. The impact: it's kind of interesting because the students did win a small victory, but it also, in the case, very importantly, the court made it very clear that if the armbands were disruptive, if people were just, fighting over, if it was creating a disturbance, then absolutely they could restrict it. So modern dress codes are all kind of born out of the standard in that instance. Okay, the Schenck case I think I've already talked about actually, but just to review it real quickly. Charles Schenck. He's a socialist. He was convicted of violating the Espionage Act. So Congress had just passed a law called the Espionage Act, and he had directly violated the law by mailing flyers to people to resist the draft. And of course, again, the issue is his conviction of he was convicted under the Espionage Act because that's illegal under the law. And the question is the law valid? And basically the answer is yes, the law is valid. And basically Congress has a lot of powers. And he was clearly interfering with the recruitment, which was a violation of the Espionage Act. Wartime is different from peacetime. So again, here's some of the highlights. When a nation is at war, many things that might be said in time of peace, such as a hindrance to his efforts, that their utterance will not be endured so long as men fight, and that no court can regard them as protected by any constitutional right. So when a nation is at war, things are different, basically. Some speech does not merit constitutional protection, so there's that erosion of the First Amendment. There are categories of speech that are unprotected. And clear and present danger speech falls in the category of unprotected speech. And then you have the famous fire in a crowded theater causing a panic line. Okay. So basically, going through the case review, guy was convicted of mailing out flyers in violation of the Espionage Act. The issue is the Espionage Act valid? Does it infringe on the First Amendment? The decision was the Espionage Act is valid because during a time of war, things can be restricted in the interest of national security. The impact was it was really a taking away some of the sanctity of the First Amendment because it opened up the idea that there are certain categories of speech that are unprotected. All right, so I hope this was helpful. Again, I can't be there in person because of the COVID protocol, and this video will be on YouTube for a while. It probably will not stay there permanently, just to get you through the week. But hopefully this helped, and I'll be back in class, hopefully on Monday. So, all right.